I want to talk about the latest developments in the Sunday ticket trial. Because I said yesterday that the thing that may save the NFL is the law. And I thought the law would save the NFL at a higher level. The law might save the NFL right here and right now because the presiding judge isn't thrilled with the case that the plaintiffs are putting on. Now, I don't want to get too legal nerd here, but remember this. The case was initially dismissed, and it was dismissed by a different judge. She has since passed. That's why a different trial court judge is handling the case. But the case was initially dismissed at the request of the NFL. The Ninth Circuit Court of Appeals overturned the ruling, sent it back to the lower court for a trial. And in January, the presiding judge determined, in ruling on what's called a motion for summary judgment. And I may have mentioned this recently. Those get filed in almost every complicated case because the defendant wants to say, hey, judge, there's no reason for a trial. There's no issue that a jury needs to decide. Based upon the facts that are undisputed, apply the law and we win. Happens all the time. And for a variety of reasons. A lot of times the defendant doesn't expect to win, but what the defendant's trying to do is to force the plaintiff to put some cards on the table, because to beat back a motion for summary judgment, the plaintiff's got to articulate why the case works, how the logic holds together. It's a great way to get a peek inside the hand of cards that the plaintiff is getting ready to eventually put on the table at trial. The judge denied the NFL's motion for summary judgment in the Sunday ticket case. So the judge decided, hey, there's something there that a jury needs to decide. Now the judge is upset. And this happened, and it hasn't been explained very thoroughly in the reports I've seen out there. And I know, I could have shut down everything I'm doing and gone to Los Angeles and sat in the courtroom all day and written a story or two or three or four at the end of the day that gets into all the nooks and crannies of everything that happened. And part of me thinks maybe I should have done it, but the other part of me says, first of all, I don't want to go back to LA until I have to. And second, all due respect. And second, I got other stuff to do. I got to prioritize how I'm going to allocate my own time, my own personal resources for something that adds how much? I don't know, to the broader effort of what we're trying to do here. But against that background, I'll say this. The coverage has been lacking. And things aren't explained the way they should be. One thing that wasn't explained in the reporting I saw yesterday, because it creates the impression this all happened in front of the jury. It didn't. The jury's not in the room when the judge says to the plaintiff's lawyers, basically, your case stinks. Your case is weak. You've overcomplicated your case. I don't like your case. I might throw your case out. And I think that happens for a very simple reason. And this is a dynamic that I've experienced in the legal practice. Typically, it happens on the defense side. When you've got these firms, and what occurs is firms grow and are fueled by large firms, typically by having a bunch of corporate clients that are charged significant hourly rates. Cost-insensitive clients is what they told us at the first firm I worked for when I got out of law school. They want cost-insensitive clients, meaning we got a big problem. We don't care what it costs. We're not going to micromanage the bill and say, why did it take you a half hour to do this? Why did it take you 45 minutes to do that? Why did it take you 2 hours to do this? It should have taken 1 hour, not 2. They don't want to screw around with that. They just want to be able to submit the bill and have the client pay it. Cost insensitive. So these firms grow and they become massive. And you got a lot of colleagues in the firm. And when somebody goes to trial, it's a fairly big deal because most cases resolve before it goes to trial. So it's a big event at a larger firm when there's actually a trial happening. And what happens is when you're talking to the lawyers who aren't part of the trial and are fascinated by it because we all want to go to trial, but it doesn't happen very often. So, hey, Jim's in trial. Let's talk to Jim about his case. So what happens is you get other lawyers who start saying, oh, did you argue this? Oh, hey, did you argue that? Oh, did you do this? And the lawyer does not want to say, oh, no, I didn't think of that. Or, oh, no, we decided not to. Oh, you should argue that. And you definitely don't want those questions when you lose. So defense lawyers tend to over-lawyer everything. And that plays to the benefit of the plaintiff who doesn't take the bait. And I think what happened here, and this is my estimation based upon finding whatever scraps I can via Twitter and Google searches and Google alerts and this article and that article. I think what happened in this case was the plaintiff's lawyers took the cheese and they allowed themselves to overcomplicate the case in response to the predictable efforts by the NFL's lawyers to overcomplicate the case. It's not a complicated case. And one of the points I made today regarding the testimony of Sean McManus, the former CBS Sports chairman, on the key points, when he's asked the key questions, hey, did you work with the NFL to come up with some sort of a side deal to ensure that Sunday Ticket is priced at a level where people won't buy it and they'll watch CBS free broadcasts of NFL games, even though they may not want to watch the game that's served up? He's not going to admit that. He's not going to admit that he's aware of some effort by the NFL to fix the price to protect CBS and Fox. You don't have to hammer it 20 different ways to put the ammunition out there so when you get to closing argument, you can say to the jury, look, what do you expect them to say? What do you expect them to say? They're not going to admit it. Gets to what I was talking about yesterday. If you watch yesterday's show, first of all, thank you. If I did, second of all, you may remember, as it relates to Jim Trotter, I said in employment cases, they never admit that they fired somebody for discriminatory or retaliatory reasons. They have an official story and they're sticking to it. And there's this issue of individualized perjury versus institutional perjury. And is it really perjury? I don't know what it is, but it is, we have our story and we're sticking to it. And the story is, we have no power over what Sunday Ticket costs, and there's no side deal with CBS or Fox. Every time CBS and Fox in these negotiations expresses concern about Sunday Ticket, and at the end of the day, there's nothing in the agreement that requires the NFL to keep Sunday Ticket at a certain price, but Sunday Ticket is still kept at a certain price. Oh, but there's no side deal. Now, maybe there was no need for a side deal. Maybe the side deal is implied. Maybe people who are smart enough to understand what CBS and Fox were looking for understand, okay, we got to make sure this thing is a certain price because we don't want to piss CBS and Fox off here and cut into their ratings. Or maybe there was a side deal that no one's going to admit to. Haven't we all had, at some point in our lives, a conversation that never happened? Someone will say something to us and say, this conversation never happened. And it's usually about stupid little gossipy things, but sometimes it's about important things. Wink, wink, nod, nod, this conversation never happened. Hey, off the record, way off the record, off the record, deep, deep undercover. Here's what I need, but I never said it. When you make that social compact with someone else under whatever you call it, let's just call it, this conversation never happened. When you come to that agreement, you take an oath. So which oath do you honor when it's time to testify? Do you honor the this conversation never happened oath? Or do you honor the oath to tell the truth, the whole truth, and nothing but the truth? And haven't we seen TV shows and movies where you have people who are in that conflict in different settings, but you've kind of already given your word that this conversation never happened. And if you are ever known in your social circles and business contacts as somebody who can't be trusted, you're worthless. So anyway, I don't know what happened here, but it seems to me that the reason the judge is upset with the plaintiff's case is they have grossly overcomplicated, because I think all you have to do, get enough evidence in so you can go to the jury and say, look, you heard Beth Wilkinson in her opening statement say, this case is about choice, and we also want to have the biggest possible audience watching NFL games on free TV. Both of those things can't be true. Both can't be true, because if they wanted maximum choice, Sunday Ticket would be cheap. If they want to protect CBS and Fox broadcasts on free over-the-air channels, Sunday Ticket would be expensive. What is Sunday Ticket? It's expensive. Therefore, they had something going on to ensure that it's expensive. Why would they want to infringe upon your choices? Why would they want to make it too expensive for you to buy it? Why would they sell Sunday Ticket as displaced Packers fans in Pittsburgh can watch Green Bay games and force them to buy the entire season of all teams if they didn't want people to say, shit, I can't afford that. I'll just watch the Steelers games. So that may be what happened. And that was one of the big challenges. And when I was getting ready to try cases, I would always look at, what do I need so I can go to the jury and say, here's what happened. And there are certain facts you have to get in, and you don't have to get them in 50 different ways. Just get them in one way. Try to get them in an effective way, and then you can remind the jury of it, or show the document, or play back a snippet of testimony if they allow that. Depends upon the court. That's the way to do it. And I think the plaintiffs' lawyers, because the NFL, as defendants usually do, has overcomplicated the case. I think the plaintiffs' lawyers have overcomplicated what should have been a very simple case, and it could end up being fatal. Now, one last thing. I think the threat to throw out the case is a hollow one, because at this point, you just let the jury decide it. And if the jury finds in favor of the NFL, you don't have to get involved if you're the judge. Now, what could happen is there could be a verdict against the NFL. It'll make headlines, and then the judge at some point later will say, I'm entering judgment for the NFL, notwithstanding the verdict. That could happen. I think this was, more than anything else, a warning shot at the plaintiffs to move this thing along, quit dragging your feet, quit complicating the case. It's simpler than it needs to be. And I think that the plaintiffs' lawyers would be wise to heed that and move the case along. Hi, it's Mike Florio. Thanks for watching PFT on YouTube. Hit subscribe for the latest news and analysis from Pro Football Talk.